Okay, I think we will let people get in before we get started. It's not quite 12, so we have just a couple minutes.
Sounds good. Oops. Okay, so that's how I was just trying to figure out how to make these slides work, and I did something and it moved. Oh, there we are. Now I see those
Okay.
things at the bottom.
So I guess we can get started. Do we have everyone? I guess people can kind of drift in, but I think we're getting right to the hour. So I wanted to again give a hearty thanks to Marilee Rasmussen, who has agreed very kindly to share her time and talents with the Lost Society of Nunavut with this presentation. Marilee is counsel for the public guardian and public trustee of Nunavut. And as such, today she's providing us some insight into adult guardianship under the Guardianship and Trusteeship Act. So I won't take up her time, just suffice it to say thank you very much. And we're always grateful when people present. And we're particularly grateful because Marilee has done, this is her second presentation. And so we're doubly grateful. So thank you again. And I will cede the floor to you.
Okay, thanks a lot, Rebecca. And I do appreciate the opportunity to talk about what I think is an important topic, especially in Nunavut. Things are done kind of differently in the north in many respects, and this I think is one of them. And as Rebecca said, I wanted to talk about adult guardianship. This is a situation when a person who is an adult needs help. And we have the Nunavut legislation that applies as the Guardianship and Trusteeship Act. And I did want to thank you for making it clear, Rebecca, that I'm not the public guardian and trustee. I'm legal counsel for the public guardian and public trustee. I think I've been doing this now for almost 8 years, or maybe exactly 8 years, which is amazing to me that it's been that long already. So I wanted to just talk in sort of, first of all, in general terms, and then specifically about some of the provisions of the legislation that relates to this issue. And to say, first of all, maybe something obvious, but guardianship and trusteeship can only be ordered where an individual lacks capacity. And it governed in Nunavut by the Guardianship and Trusteeship Act and requires a court order. I know in some southern jurisdictions that isn't always the case, but in Nunavut, there's no guardianship or trusteeship unless there's actually an order of the court. I'm going to focus on guardianship orders in this discussion today. The principles apply to both situations, but most of the guardianship orders that exist in Nunavut, or sorry, most of the orders that exist in Nunavut are with respect to guardianship and not trusteeship, because of course trusteeship involves managing people's finances, and that has generally not been an issue in terms of there being huge numbers of people with property and financial concerns that require assistance in this way. So capacity, of course, is the important issue. And Section 1.1 of the Act establishes a presumption that every adult has capacity. And you see, I've put the provision there. It's very important to keep in mind that we start from the presumption that an adult has capacity. So a person who, and actually I think adult under the Guardianship and Trusteeship Act is defined as age 18, not 19. Not sure about why that difference, but in any event, any person who's 18 years of age or older is presumed to have capacity for the purposes of this legislation. They're presumed to be able to make decisions about their own health care, personal care, and well-being, as well as financial matters. And the these issues don't come up in courts very often, particularly with respect to guardianship, because the issues, because litigation is so expensive, the issues involving personal guardianship really don't find their way into court very often. But there is a one case that you could look at that talks about this presumption of capacity, fairly recent case in Alberta, under appeal to the Alberta Court of Appeal. That was a leave application, I believe, that I've referred to down at the bottom of this slide. But I would be surprised if the Court of Appeal took any different kind of position with respect to this. It's kind of axiomatic that you're presumed to have capacity, although I think we have to remind ourselves of that from time to time. And maybe I should also mention at this point that when a person has capacity, they can make bad decisions. You know, we don't all make the best decisions we could make every time we're called upon to make a decision about our own lives. But if we have capacity, we have the right to make decisions that are perhaps bad by someone else's standard. And under the Nunavut Act, capacity is in effect defined under Section 7(1)B, which talks about the circumstances that have to be in place in order for a court to make an order. So it has to be established that, and the parts in italics in that slide are quoted from the legislation. So it has to be established, amongst other things, that the person isn't able, either by themselves or with assistance, to understand information that's relevant to making a decision around personal issues or financial issues, or it's not and, it's or they're not able by themselves or with assistance to appreciate the reasonably foreseeable consequences of a decision of that nature, or a lack of a decision. So it's necessary to be able to understand the consequences of making the decision or not making the decision. And in addition to one or other of those circumstances being present, there has to be some indication that the individual will substantially benefit from a guardianship order. And we've made the argument that there's no substantial benefit to a guardianship order when a person is, for example, perhaps assessed as not having capacity, but they're living in the community. They may be living with family. There's lots of supports in the community to assist them, and really a guardianship order isn't going to make any difference to their quality of life, and therefore there's really no good reason to have an order that deprives them of the ability to make decisions for themselves. There's a similar, I'm just reaching over for my copy of the act because I didn't include the provisions from Section 12(1) on the slide there, but Section 12(1) of the Act also talks about a kind of other side of the coin definition of capable. And in Section 12 is the section I'll talk about more in a minute. It talks about what guardians are required to do when they make decisions for persons in respect to whom they have an order. But a person is capable if they're able by themselves or with assistance to understand information, as is described there, or if they have the ability by themselves, and in this case, and they have the ability by themselves or with assistance to appreciate the consequences of making or not making a decision. So Section 12(1) actually is I think that would be appropriate to describe it as a mirror image of what Section 7(1)B is saying in terms of determining when a person lacks capacity sufficiently that the court has the ability to make an order. And guardianship orders must also be as minimal as possible, that we're talking about an individual's right to make decisions for themselves, and that right should only be taken away to the extent that's absolutely necessary. So a guardianship order should be the least restrictive possible in order to achieve the objectives of the legislation and to appropriately provide decision-making ability for the individual who needs help. So where there is another less restrictive alternative available, the court cannot make the order. And so you see here, this is subsection 7(1.1) of the Act. So 7(1) says to the court, you can make an order in this circumstance. And subsection 1.1 is saying, but if there is some less restrictive way in which you can deal with the needs of the individual, then that is the path that you should take. And there's also a case involving this kind of issue that I referred to at the bottom of the slide that you can take a look at. Again, there's not an awful lot of recorded decisions relating to these issues. We make these guardianship applications on a regular basis, and probably over the last 8 years, I've no doubt made hundreds of these applications. I think the number of situations in which we have written decisions from the court is probably, if I remember correctly, there's only about 3 or 4. So most of them are straightforward, and most of them involve situations where there is no disagreement or argument. But these are the circumstances that have to be in place in order for the court to make an order. And I just wanted to talk a little bit about what it means to have authority with respect to adult guardianship, and in particular to contrast that with orders regarding children. Adult guardianship does not involve the provision of services to the person who's the subject of the order. What guardianship orders do is provide authority to the guardian to make decisions for the person who's the subject of the order. And Section 12 of the Act provides a long list of directions to guardians about how they are to exercise their decision-making function. And this particular case that is referred to on this slide is one that does deal with the issue of what is the responsibility of a guardian, and in particular, in that case, the public guardian, with respect to persons under guardianship, and it involved the claim that that the public guardian was responsible to provide the individual under guardianship with a place to live, because the authority granted to the public guardian was to provide decisions, or to make decisions about where the person should live. An interesting case, and one that was actually taken to the Nunavut Court of Appeal, but does conclude that the authority of a guardian is to make decisions, not to provide services. Actually, if one thinks about it, nobody would likely often want to be a guardian if it meant that by having decision-making authority, they had to provide, a place to live, food to eat, clothes to wear, et cetera, et cetera. So Section 9(2) of the Act requires the court to review, in an initial guardianship order, to specify the time, which has to be within 3 to 5 years, within which the guardianship order that it makes has to be reviewed. And so the point of this is that no guardianship order in Nunavut is ever permanent. At least every 5 years, that order has to be brought back to the court, and the court has to be satisfied that the circumstances that provided jurisdiction to make the order, that is Section 7(1)(b) and its definition of lack of capacity and substantial benefit, that those conditions still apply. And if they do, the court can continue the order, but it must come back at least every 5 years. And sometimes the court will say less than 5 years because of the particular circumstances of the individual in the case. As you'll appreciate, many times the reason for granting the guardianship order is one that is not likely to change. Persons who are compromised from birth, or persons who, as older adults, develop dementia, are not likely to improve over time. But sometimes people have conditions that could improve, and in those situations, the guardianship order might be reviewed in a period of time as short as 3 years. The Act also allows the court to impose other requirements depending on the circumstances of each individual case. And that doesn't happen very frequently, but it does from time to time. In fact, I'm hard pressed to think of a particular one at this moment, but it seems to me we have had orders that occasionally will have other factors or criteria included in them. Most of the guardianship orders that we apply for are obtained for a period of 6 years because they have to be reviewed at least after 5. Often the circumstances, as I mentioned, of the person under guardianship are unlikely to improve. And in those cases, we ask the court to provide for the review period to be the 5-year maximum because there's not likely going to be any change. And of course, the more frequently they have to be brought back to court, the more difficult it becomes in terms of all the resources of the Office of the Public Guardian, the court, etc. To, oh my goodness, what happened here? I touched the mouse and everything moved. One sec. Okay, so in some circumstances, a person's situation can change for the better. We have made a couple of applications over the years in which a person's situation has improved so that we have deleted some of the decision-making authority as a person becomes able to make those kinds of decisions for themselves. And this is in keeping with the requirement that an order be the least restrictive possible. And we would do that on behalf of the public guardian when the circumstances change. We wouldn't necessarily wait for the review period to arrive. If a person's circumstances improve to the point where the order should be amended after 1 year, we would make an application after 1 year. We wouldn't wait for 5. So the role of the guardian then, generally speaking, is to assist the person under guardianship to make decisions in those areas where the court has determined that they're unable to do so on their own because they lack capacity, as we've previously seen. And the other important function of the guardian is to advocate on behalf of the person under guardianship. This is certainly an issue that the public guardian takes to heart quite significantly and advocates very strenuously with respect to services provided to persons under guardianship by family wellness or health, and advocates vociferously on their behalf on a regular basis. I mentioned Section 12 earlier, and this is, as I said, a lengthy provision that talks about how guardians are required to exercise their decision-making authority. And there, as you can see, are many different subsections of Section 12. We saw that subsection 1 talks about what it means to have capacity. And subsection 2, for example, is a general requirement that a guardian act diligently and in good faith. Subsections 3 and 4 talk about explanations, like a guardian has to explain things to the person under guardianship. They can't just make a decision without any sort of conversation or consultation. And to the extent that the individual is able to understand, they should be involved, in the decision making. And subsection 5 stresses the importance of language and ensuring that, where it's necessary, that interpretation is available to make sure that the person under guardianship understands what's happening to the extent they can. Subsection 6 contains a number of principles of decision making, and there, for example, if a person had capacity at some point in their life, say an individual who has dementia, who just develops dementia over time, but maybe they expressed before they got dementia, they expressed a particular view of what sort of things what kind of decisions they would make for themselves in respect of personal matters or financial matters. And if they have expressed an opinion while capable, that is what the guardian should do. And last week I talked about powers of attorney, personal powers of attorney, which are only possible in Nunavut at common law, and which cease to be valid once the person loses capacity. Here's a very important reason why it would be helpful for an adult who has capacity to have a power of attorney, because then the ultimate guardian would have to make a decision in keeping with their wishes that they expressed. If they don't have um, any previous expression of interest, then the guardian is required to act in their best interests. And subsection 7 of section 12 talks about a definition of what best interests involve. Subsection 8 encourages participation. This is participation by the person under guardianship in the decision-making process. So it's not a situation where the guardian just goes off and makes a decision and sort of the person under guardianship is just kind of like a recipient. They need to be involved. They need to be encouraged to be involved. And as well, the guardian should engage family and friends who may be able to shed some light on what a person's wishes might have been when they had capacity. That there's the requirement that a guardian consult with family and friends and foster independence, which I think is an important feature as well, that all of these things go to the issue of fostering the independence of the person under guardianship, just hopefully to the point where they can make those decisions by themselves. And again, we see the notion that the least restrictive course of action is the one that the guardian should take. Now, the Act also talks about who may act as a guardian, and this is all laid out in section 8. The public guardian, of course, can always be appointed as the guardian for an individual, and there are a number of orders in Nunavut that appoint the public guardian as guardian or as alternate guardian. But if it's a personal appointment, then the individual who would wish to be appointed as the guardian for a person has to have had what the Act describes as friendly personal contact in the last 12 months. And that is, you want to be sure that the person who is appointed as guardian is a person who has the best interests of the individual in mind and who will make decisions appropriately for them. And that's, I think, why the Act talks about friendly personal contact. The guardian, a person appointed, private guardian appointed as guardian, has to, of course, act in accordance with the Act. And as I've noted here, especially section 12, which we just went through, that talks about all those obligations that would be imposed on a guardian in making decisions for and on behalf of persons under guardianship and involving them in that decision making. The individual must not have a potential conflict of interest by being appointed as guardian. We've not had a situation of that nature occur in the various applications we've dealt with, but it is a requirement that there be no conflict of interest in terms of appointing a person to act as guardian for obvious reasons. And the person has to be a suitable person and able to act as guardian. That's a rather general description. I'm trying to think, have we had a situation where a person has not been suitable? And I can't think of one. The public guardian, of course, would consider when a private guardian or proposed private guardian steps forward, the public guardian does look into the matter to see if there is any red flags in relation to the issue of suitability. And then, of course, ability. Sometimes a person, a family member in particular, might be willing to act, but, for their own reasons, perhaps health reasons or age, they're not able to act as a guardian. And finally, an individual who is a private individual has to be a resident of Nunavut. You'll see here I've referred to another recorded decision of the Nunavut Court of Justice with respect to this issue. And there were one or two other decisions where reasons were not provided in writing. But in this particular case involving Eaton, the individual in question was in a facility in Ottawa because the sorts of care needs that she had were not available in Nunavut. And her spouse was also in Ottawa to take care of her. The court determined that the spouse could be her guardian, even though, in one sense, not a resident of Nunavut, but a person who had lived in Nunavut for many, many, many years, and for the same reasons that the individual who is the subject of the guardianship order is still considered a resident of Nunavut for guardianship purposes, the partner of that individual could also be named as a guardian, even though not physically present in Nunavut at the time. And Section 25 of the Act directs the public guardian to apply for guardianship where a person is in need of a guardian and there's no suitable person who's willing and able to make an application. In that sense, the public guardian is the guardian of last resort. And many times the public guardian does make that application with respect to guardianship to ensure that the people of Nunavut are properly looked after and cared for, and that there's someone to act on their behalf. I mentioned kind of in passing that there's sort of different categories of people about whom guardianship orders are obtained. And they sort of fall generally into these kind of categories. The older person who develops dementia or Alzheimer's, those kinds of things later in life. They had capacity at one time, but no longer do. Persons who have developmental or intellectual disabilities, and these are oftentimes individuals who have issues that compromise them from birth, anoxia at the time of birth, or something like meningitis as an infant that results in developmental or intellectual disabilities, sometimes which are very profound. There's also persons who have mental health disabilities or persons with acquired brain injuries. A few statistics, they're getting kind of old, but I think illustrate sort of the magnitude of the issue, and in particular the issue concerning dementia and Alzheimer's. I don't know what the experience of others has been, but it seems to me that more and more I see situations of people that I know and family members who do develop dementia, sometimes at a very young age. It's kind of surprising. But you can see that the Alzheimer's Society is estimating that by 2038, I guess it would be, that the population in Canada affected by these kinds of conditions is likely to double. Those percentages are still looking low, but almost 3% of the population in the next, what is that now, 15 or so years, is a significant number of people. And of course, aging in place is the goal of the vast majority of people. But as age increases, so does the likelihood that you'd be living in a retirement home, a long-term care facility. And approximately 1/3 of individuals in Canada over the age of 85 live in that kind of a situation. Developmental disabilities, as you see, the statistics, again, the percentage is low, but absolute numbers are significant. And in particular, when those absolute numbers include, people or people in your family. And it's important that that these individuals be properly looked after and decisions be made for them appropriately. The disability is a label and it follows people throughout their lives. There's been a case in Saskatchewan just recently that involved an individual with Down syndrome who was living in a group home and didn't want to have anything to do with her father for a whole variety of reasons that I needn't go into. But he made an application to the court to require the court or ask the court to order that she be required to see him. And she objected to that. This matter went to the Court of Appeal, and the Court of Appeal said, sort of along the lines of an earlier part of this discussion, she has capacity until you demonstrate otherwise. And the mere fact that she is a person who's been diagnosed with Down syndrome doesn't mean that she lacks capacity. So I think it was an excellent decision on the part of the Court of Appeal in Saskatchewan, but also reflects the sort of popular thinking that if you have some sort of disability or mental illness of some kind, that you lack capacity generally, and that's not true. It's also true that persons with disabilities are living longer than was the case, many years ago, and their primary caregivers tend to be parents or other family members, and there's now the concern that an individual who needs assistance will not have that assistance available at some point in their lives. Mental health disabilities includes a wide range of conditions. Some are very severe and some are less severe. Some of them would result in impairments to understand information, to appreciate risks of various courses of actions, and some don't. Some mental health disabilities can be episodic rather than chronic, and often lead to issues around unemployment and underemployment, lack of access to safe and affordable housing, appropriate educational opportunities. All of these things contribute to poverty among persons with mental health disabilities and exacerbate the illness that they already have, reducing their options. But as I've noted at the bottom of the slide, the mere fact that a person has a mental health disability does not necessarily mean that the person lacks capacity or that they lack capacity in all circumstances. The Ontario Brain Injury Association found that 95% of respondents had trouble with their memory. That is 95% of respondents who had brain injury. 93% had trouble concentrating. 91% had trouble making decisions. 80% experienced anxiety, and most reported depression and trouble controlling anger and mood swings. And we see those behavioral issues in persons with living with acquired brain injury. And we have had a few situations where the capacity issues experienced by the person under guardianship in Nunavut is because of acquired brain injury. As everybody knows, the lack of adequate facilities in the territory leads to placement of individuals in facilities in the south. And this has the unfortunate result of isolation from culture, family, and community. And it's difficult to make the decision to have a person placed in a facility. Ultimately, the goal would be to have those kinds of services and facilities available in Nunavut, and some efforts are made in that regard, but it's a long-term issue. It's also important to recognize that a guardianship order shouldn't be required in order for a person to be placed in a facility can meet their needs, although sometimes that seems like it's the case. That and I understand the concern being that if a person doesn't have a guardianship order that allows someone else to make the decision on behalf of the individual, they can change their mind and want to leave the facility, and this causes some difficulties. But again, the inconvenience is not the criteria for making a guardianship order. And individuals who have a need for specialized care are not necessarily lacking in capacity. I had a friend and client here in Saskatchewan who had very significant physical conditions. She had diabetes that affected her eyesight, her ability, her mobility, all of those things. And at one point she was, I think in the territory we say formed, and had to appeal the conclusion that because of all of these physical disabilities, that she lacked mental capacity, but she had certainly the ability to make decisions for herself, even if she couldn't do a lot of things for herself physically. Private guardianship is difficult. I think it's kind of difficult in anywhere, but especially in Nunavut due to access to justice issues. There's a lack of private practitioners in the territory. The Legal Services Board does get involved from time to time, but I understand that there are criteria to be met in order to qualify for assistance from the LSB. And the cost of the capacity assessment report, which is a required feature of a guardianship application, there has to be a capacity assessment that's provided by a medical practitioner or a psychologist registered in the territory, or a person appointed by the public guardian to make that report. The report itself is a prescribed form under the Act, in the regulations made under the Act prescribe the form that is a kind of checklist form that asks many questions about what a person is able or not able to do. And but that cost can be significant. And and of course, when things become that costly, it makes a barrier to getting access to service. As I mentioned earlier, public guardianship is a last resort where there's no family member willing and able to act as guardian. The public guardian frequently, though, acts as an alternate guardian. And so this would be a situation where the private guardian family member is appointed as a private guardian and the public guardian is appointed as an alternate. And Section 17 of the Act talks about alternates and their authority. Oh, darn. I guess I shouldn't touch the mouth at all. In any event, Section 17 allows the alternate guardian to act where there's a written authorization to do so in the absence or disability of the person appointed as guardian. So guardianship orders in Nunavut fall, I think, approximately equally, although I haven't, done a sort of formal study of all of the applications that we've done, into one of three categories. First of all, the persons who develop the cognitive disabilities as they age. The second category would the persons who have the intellectual or developmental disabilities from birth, and in some cases those are very profound. And then there's the persons who have mental health disabilities of various kinds. Frequently, those have been diagnosed as drug-induced schizophrenia and or psychosis or acquired brain injury. So the application process involves a number of steps. You'll see there's a referral, there's a capacity evaluation, preparation of the documents for court, services of those documents, the hearing, and finally an order. The public guardian typically receives a referral from a family member or sometimes from the health or social service professionals in the community. And that referral will request the public guardian to arrange for a capacity evaluation of the individual. And that's the evaluation or the capacity assessment that I was speaking of earlier. Those referrals can also contain other detailed historical information as background to the request. And oftentimes if the referral comes from the health center in the community, there will be the individual's file will be provided. The public guardian's office follows up on those referral requests to make an initial determination as to whether there is likely to be a lack of capacity issues that should be referred for assessment. And again, the assessment process is an intervention that is both expensive and it's an intervention. And if it's not necessary, it shouldn't happen. A capacity assessment cannot be forced. The individual has to expressly consent, or they have to participate in a manner that indicates that consent is implied. As I've said earlier, the capacity assessments are usually conducted by psychologists, but it's also possible to have a person assigned to do to do a capacity assessment, assigned by the public guardian, that is. I don't believe there's any psychologists that are actually resident in Nunavut. There are half a dozen or so psychologists who are qualified and registered in Nunavut to provide services in the territory. So the psychologist then interviews the individual and may interview caregivers and family members and provides a report outlining their professional opinion concerning the individual's capacity in accordance with those criteria we discussed way back at the beginning. So those reports typically consist of that mandated assessment report that's referred to in section 2.2 of the Act, the prescribed form. And there's also usually a more descriptive narrative report that accompanies the prescribed form and provides more explanation. The application documents themselves include a petition, an affidavit of each petitioner in support of the petition. And so when there's a private guardian being proposed to be appointed, that would include an affidavit from that person indicating their willingness to act. There's also a separate document that is a consent, because a guardian has to consent to act, and that's formally documented in writing. The assessment report itself that we just talked about, draft orders, and a memorandum to the judge. All of those are included in the application package. In addition, we provide the respondent as well as their nearest relative, which is a term defined in the Act, with a plain language letter, the Nunavut Legal Services Board brochure about the services they provide, the court's translation services endorsement, and a notice to appear by telephone form so that they can, if they wish, participate in the process. Application documents have to be served on the respondent's nearest relative, the facility where the respondent is residing, and the public trustee. Now, the reason why the Act says the public trustee is because up until April 1st, 2020, the public trustee was a separate office. And in fact, the offices are now combined, but in a kind of practical sense, that the same person is appointed to be public guardian and is appointed to be public trustee. The actual appointments occur under different legislation, but the same person occupies both offices, and the physical office and all the support staff for the public guardian and the public trustee, it has been combined since, as I say, April 1st, 2020. As a result, it's not necessary to actually formally serve the public trustee, or vice versa for the public trustee to serve the public guardian, since it is the same individual. Nearest relative is the term defined in the Act. It's the person whose legal relationship to the respondent is the closest, so first of all, it's kind of degrees of, what's that term? Affinity and consanguinity, I think. So, first of all, a person's spouse would be their nearest relative. If there's no spouse, it's their children. If there's no children, it's the grandparents, I believe. I might not be remembering that correctly, but in any event, that list occurs in the definition section of the Guardianship and Trusteeship Act. And it's, I think, confusing sometimes for people involved in the process, because sometimes the person who has the most to do with the individual who's to propose to be under guardianship is not their quote nearest relative, and that term is kind of misleading in that sense. So service of those application documents has to be made at least 10 days before the hearing date when the person is located in Nunavut, or 30 days prior to the hearing if they're outside Nunavut but inside Canada. We rely on community service workers, mental health workers, or others in communities to serve documents in Nunavut, and then on the employees of facilities or process servers outside Nunavut to serve respondents. The facilities themselves, of course, we can serve by email in accordance with that practice directive from the Nunavut Court of Justice. We schedule hearings in the community where the respondent is residing, where they're in Nunavut. So sometimes, for example, there's a continuing care center in Cambridge Bay, and if the individual is in that continuing care center, then we would schedule the hearing to be held in Cambridge Bay. If the respondent is outside Nunavut, we would schedule it in the community where either the proposed private guardian or the nearest relative is residing. In cases of urgency, the hearing is scheduled in Iqaluit because there are guardianship hearing dates every month in Iqaluit. And when we're scheduling in communities, it's the civil date in that community, which, as you will be aware, in some communities is only twice a year. Ex parte applications are permitted in certain circumstances under Section 10 of the Act, and I think I have a little more detail about that following. The court prefers that proposed private guardians and respondents participate in person or by telephone or virtually these days, although that's not always possible. But wherever it can be arranged, we try to have everyone present. It makes it a lot easier for the court to understand what's happening and to see the individuals involved. Be able to speak to the person who's proposed to be under guardianship, I think, is also helpful for the court. And of course, the court can only make that order where the requirements of the Act are met. Section 10, the temporary guardianship order, that there has to be no order in place at the time, and the court has to consider the respondent to be an adult in need of a guardian. So that's test we talked about, lacking capacity. And in addition, there has to be a risk of physical or mental abuse, neglect, or deprivation of liberty or personal security. And those applications can be made ex parte. We've done that a couple of times when those circumstances have been present, and then it's typically followed up with the more usual application. And that's in part because a temporary guardianship order can only be made for a 3-month period and can be only extended for one additional 3-month period. There's no temporary trusteeship order available under the Act. So just to kind of bring this all together, adult guardianship is a significant intrusion into the right of the individual to make decisions about their personal and financial affairs. And for that reason, the Act requires an order of the court to be made and periodically reviewed, and that only the interference by virtue of an order is only to the extent necessary that is required to assist the individual to make those important life decisions. And as a concomitant of that, the Act also requires that guardians exercise their decision-making authority in accordance with those principles outlined in Section 12, and most importantly, to involve the individual in decision-making to the extent that that is possible. And I hope that that has explained the situation, but if you have any questions, I'm happy to try to answer them.
Well, a big thank you again, Marilee, for your presentation. It's extremely helpful to have your wisdom and expertise on this. This presentation will live on as a video on our Law Society of Nunavut website, so you may actually get questions later.
Oh, and that's fine. That's fine. I'm
Yeah.
quite willing to answer questions at any time. If anybody has any thoughts or concerns or questions about any of this this area, I would be happy to respond.
Wonderful. Thank you so much. Great. Well, it looks like we might be giving ourselves a few minutes back into our day, perhaps to stretch and drink coffee. I don't know. So thank you again for your time and for your generosity in providing this presentation.
No problem. Thanks a lot, Rebecca.
Thank you.